You think that a simple will is going to be the cheapest and easiest way to protect your family. But the cold, hard truth is that a simple will is going to force your family to end up in the probate courts when you pass away. That means that the assets you're trying to pass down to your family can be stuck in the probate courts for 12 to 18 months, and it could cost your family 3 to 8% of the total value of the assets you're trying to pass down to them in attorney fees and court fees. But I'm going to show you the tool that will allow your assets to avoid the probate courts altogether, keep your assets private, save your family 12 to 18 months, and 3 to 8% of your estate. This is going to be especially important if you own property out of state, like a vacation home or rental properties. So let's talk about the hidden 8% inheritance tax. The problem when you have a will is that your assets are still in your personal name when you pass away, and any assets in your name when you pass away will have to go through the probate courts to be distributed out to your family. Probate is the court supervised process of validating your assets, paying off your debts, and then distributing your assets out to your beneficiaries. It's not fast and it's not cheap. We see this happen all the time. So let's say you have a $500,000 estate, whether it's property, investment accounts, or whatever. Your family could end up spending $20,000 to $30,000 in court and attorney fees. The problem with this is that that is money that your family was intended to have. You worked your entire life to save up for these assets, to pass them down to your family, and you're losing them to probate attorney fees. On top of that, your family cannot access these assets or have any control over these assets during the probate process because they do not own those assets. Your estate owns those assets, and they have no ownership or authority over them. So the problem is going to be, while your family needs that money to help them survive after you've passed away, they have no access to those assets to help them with that. The other problem is going to be privacy. When your assets are going through the probate process, your will, your assets, and who those assets are going down to is all public information that anyone can look up. This is going to be a gold mine for your nosy neighbors who just want to meddle in your affairs. The good news is that there is a way to get around this that most people are unaware of. Now, I already know what you're thinking. Trusts are only for the super wealthy, and that's going to be the biggest and most dangerous misconception about estate planning. Honestly, the wealthy people are going to be just fine. It's middle-class families who benefit the most from trust setup. The reason being is that losing 3 to 8% of your stock portfolio or your home's value or your assets being forced to be sold to pay off debts that you have, that is what's going to keep you from being able to pass all of your assets that you've worked your entire life for down to your family to help them out. So it's not really about how much money you have right now. It's about how much money you're going to be saving your family, the headaches you're saving them, and the time that you're saving them from the probate process. So let's talk about the 5 reasons you would want to consider a trust. So the first one is going to be if you own property that's out of state, whether that's vacation homes, rental properties, or farmland. When you pass away with those assets in your personal name, you will have to open up the probate process in each of the states that you own property in. And so your family is going to have to open up the probate process in the state that you live in, and then a separate probate process in each of the states that you own property in. And when they do that, if they need help from a probate attorney, they will have to hire a separate probate attorney for each state that you own property in. And so if you're going to spend $10,000 to $15,000 per probate attorney, you're going to pay that for each of the probate attorneys that you hire for this process. But when you put those properties inside of a revocable trust, they will all avoid the probate process because the assets are owned by the trust, and in the name of the trust, they are no longer in your personal name. Therefore, when you pass away, they do not have to go through the probate process in each of the states. It will avoid the probate courts altogether, saving your family from having to go through the probate process in each of the states that you own property in. The second one is going to be incapacity planning. So when your assets are in your personal name and you become incapacitated, whether that's a healthcare emergency, a car accident, or you get dementia or Alzheimer's, your family will have to go to the probate courts and get special authority to manage your finances on your behalf. Now, when your assets are inside the revocable trust and you become incapacitated, your backup trustee will step in your role as trustee and take over the management of those assets without the court's involvement. It's immediate. Now, if you want help setting up a revocable trust, click the link in the bio, fill out the form, and schedule a time to talk to someone on our team. The third one is going to be if you have a blended family. So let's say you had a family, you got separated, and then you got remarried, and now you have a blended family. The risk that you face is that your children could accidentally be disinherited, even if you unintentionally made that happen. So when you put your assets inside the revocable trust, you can put special rules inside that trust document that will allow your current family to be taken care of, like your new spouse. But then when you pass away, you can make sure that those assets are going down to your children and that they are not accidentally disinherited. The third one is going to be if you have special needs family members. So if you give that money directly to those individuals and they are on government programs that give them benefits, they could be disqualified from those benefits if you give them that money in their personal name. What you can do instead is leave that money or those assets inside of your revocable trust when you pass away and allow them to benefit from those assets, but not distribute those assets out to them in their personal name. That way they are not disqualified from those benefits. benefits. The fifth one is going to be if you want to keep everything private. So again, if your assets are going through the probate process, it's all public information. Anyone can look up your estate, see what assets you had and who those assets are going to. But when you put your assets inside that revocable trust, it will avoid the probate courts when you pass away. Therefore, it does not become public information because a trust document is a private document. The only people that you have to give that information to is going to be your trustee, which is typically going to be you, and your successor trustees, so they have an idea of what's going on when they need to take over the management of the assets inside that trust. And then you have the option to show your beneficiaries that trust document, but you don't have to. Therefore, the trust document is completely private and no one can see it because it's not public information. So let's talk about the bulletproof estate plan. It's going to be the two estate planning documents that go hand in hand. They're very important to make sure that your assets are going down to your family and they're taken care of. The first one's going to be the revocable living trust. You would put your assets inside that revocable trust, and then you would name the revocable trust as a designated beneficiary on your financial accounts, which would be things like checking, savings, investment, retirement, or life insurance policies if you want to. That way, all of your assets will either be inside that revocable trust or be going into that revocable trust when you pass away. That way, you can manage those assets and distribute them per the instructions inside of that trust document. Again, the benefit of this is going to be you have incapacity planning. You get to avoid the probate process, which saves your family 12 to 18 months and $5,000 to $15,000 in probate attorney fees. You get to avoid the probate process if you have properties that are out of state. And then the second one is going to be a pour over will. Now you might be thinking, why do I need a will if all of my assets are sitting inside that revocable trust? That's a great question. So the problem that a lot of people are going to have is that when they set up that revocable trust, if they're not working with a reputable estate planning attorney, they will not guide them through the process of putting the assets inside that trust, and they will not audit those assets when the trust document is complete to make sure that everything is sitting inside that trust to accomplish the goals that you have with that revocable trust. Which basically means that you set up your revocable trust for no reason because those assets are not avoiding the probate process. So now your family has to deal with the probate process, the timeline, and the expense of that, and you also spent the money on the revocable trust. The other problem is going to be is that throughout the rest of your life, when you're buying and selling assets and you have that revocable trust, people will tend to forget to put the assets inside of that revocable trust when they make the purchase of them. So when you don't have assets in that revocable trust and they are in your personal name when you pass away, they have to go through the probate process. So the pour over will take those assets that are in your personal name, take them through the probate process, and then on the back end of probate, it will dump them into that revocable trust to be managed and then distributed per the instructions inside of that revocable trust. That way, if you forget to put assets inside that revocable trust, they are still being distributed per the instructions inside of that trust document instead of being distributed per the intestate laws or an old will if you have one. Okay, so we've covered a lot here, but the main point is that even if you feel like a revocable trust is pretty expensive and that a will is going to be cheaper, when you set up the will and the assets have to go through the probate process, it's going to be much more expensive and time consuming for your family, and they're going to have a much larger headache to deal with on the back end when they need the assets immediately because they've lost your income. If you want help setting up a revocable trust, click link in the bio, fill out the form, and schedule a time to talk to someone on our team.